In this webinar, we're going to cover the following topics: fitness to plead and the application of the Pritchard test as a starting point for any defendant presenting with a mental health condition or with a history of psychiatric illness. Some criticisms of Pritchard and how the same issue is approached within the civil realm via the Mental Capacity Act 2005. An introduction to the sentencing offenders with mental disorders, developmental disorders, or neurological impairments, sometimes known as the Mental Health Sentencing Guidelines. This came into force in October 2020 for defendants which are fit to plead, but nevertheless have mental health issues to be considered by the court when sentencing. To demonstrate this, I plan to use an anonymised case example of mine, which concluded in May of 2021. I then propose to take a canter through the different types of mental health order that the court can impose if it feels necessary, how they're made, the release mechanism for them, and a few instances where some of them may not be suitable. This will involve consideration of some of the recent case law, including the case of Crown and Reynolds, which sets out the order in which the court should consider these disposals and consolidates much of the previous case law in this area. And finally, we will finish with some practical tips, including dealing with medical professionals and one of my favourite topics, the importance of sentencing notes. The next consideration for the court will be, very similarly to any sentencing guideline, culpability. And importantly, the nexus between the mental illness or impairment that the defendant is finding themselves under and the criminality that they have committed. The sentencer should first take into consideration culpability as they ordinarily would in accordance with the offence guideline. They should then seek to understand that nexus between the condition and the criminal conduct. In some cases, the condition will very heavily mitigate the offending, but that should not be assumed in all cases. Expert opinion will undoubtedly be important, but it's important to remember that the decision is that of the sentencer, and if they believe that the offending is significantly mitigated, then they should give reasons as to why. The sentencer is not bound to follow any expert opinion. Effectively, the decision remains with the judge and their discretion is not fettered. But there must be compelling reasons to set any expert opinion aside. And it really requests that the court ask the following questions: that at the time of the offence, did the offender's impairment or disorder impair their ability to exercise appropriate judgment, make rational choices, or understand the nature and consequences of their action? The court will, of course, also consider the issue of compliance with a medication regime if the individual had been formally diagnosed and subject to treatment from the medical authorities, and self-medication with drugs and alcohol when weighing up the culpability of an offender, as well as the insight that they have into their condition and how to manage it. So just by virtue of the fact that somebody is suffering with a mental health condition or disorder does not mean that it is an automatic reduction of or elimination of culpability. There are a number of factors that the judge is required to consider.